Well, today we are pleased to welcome to the studio Joe Spinelli, Senior Managing Director at Kroll, based here in New York. Joe, welcome to the studio.
Thank you.
Thank you. I'd like to talk a little more about your article in the FCPA blog titled, quote, Joseph Spinelli on the Yates Memo, expect DOJ investigations to get very personal, unquote. So, Joe, the DOJ, including Leslie Caldwell, Sally Yates, and others, have said companies don't need to boil the ocean and that proportionate investigations are all that's required. But can companies really satisfy the DOJ's requirements to tell all the facts without really boiling the ocean?
Well, I'll begin by boiling the ocean.
Okay.
I've been doing investigations in FCPA since 2005, and I can tell you that I have never once advised our client to skimp on anything, whether it's interviews, emails, or whatever, because more is better when it comes to basically doing a comprehensive investigation. I think equally as important is the fact that if you're remiss in not making some remedial actions while you're doing your investigation to show to the government that you have enhanced your compliance program to and preclude a replication of what transpired, you're going to have probably a hard time explaining to the government that you have done a complete and incisive investigation. So I say more is better. I would never say skimp. You're going to be judged on it. You're going to be interviewed on it. And what you don't want to do is place a client in a position where he or she has to say, yeah, we should have done that, but we didn't.
Right. So misses can be very expensive.
It could be very expensive and costly. Yeah, very costly.
Understood. Well, does the DOJ focus on individual responsibility? Joe, does that make it awkward for the C-suite and the board? I mean, if the DOJ is really intent on holding individuals to account, isn't everybody in the C-suite a suspect, at least initially?
I think everybody is a suspect until proven innocent, unfortunately. But the fact of the matter is that DOJ's modus operandi for these types of investigations is to basically center on lesser level individuals in the organization. And I think that what you'll see is that there'll be even greater cooperation in the C-suite. And I don't think it'll have an adverse impact that the Yates Memo is saying they're going after individuals. I think they're going to take a more active role in ensuring that they're showing the type of cooperation to get their organization the credit that they feel they'll deserve at the end of it by doing a complete investigation, naming individuals who may have been participants in that particular misconduct. And I think you'll see an even greater participation than less.
So the C-suite could end up having a more robust role in the focus on individual accountability.
Absolutely. And I can't see why they wouldn't, quite frankly.
Right.
Now, the board itself is another story, because the board, let's face it, we've been in a litigious society for quite some time, and now more than ever, board members are being scrutinized and sued for various things. I think they're also going to maintain a very active posture in ensuring that you have a corporate culture in the organization that illustrates that they have a zero tolerance for corruption. Understood.
Well, as a follow-up to that, are boards going to be forced to abandon the C-suite officers and help the DOJ or potentially lose cooperation credit? In other words, are there checks and balances to avoid what we might consider to be the coercive pressures of threatened prosecutions?
I think your CFO is a major part of the board. And your CFO is also a major part of the compliance program, if it's going to be truly effective. Because the CFO is going to take a very proactive look in putting in the type of internal controls to enjoin any potential violations for books and records. So I think that it's safe to say that the board, the CFO, and hopefully, if organizations are sophisticated enough and have a compliance committee, will all have a partake in what you just described.
Sort of a compliance executive board, for lack
exactly.
of a better word.
Exactly.
All right. Well, the DOJ said it's going to use, or it's going to increase the use of civil actions against companies and individuals. Now, do you think that's going to lower the burden for the government and put individuals at a great disadvantage?
You know, I liken this very much to 1995. When we had Operation Restore Trust. I don't know if you remember that or not, but President Clinton at the time initiated a terrific overview of the healthcare industry. And what he did was the following. the government recognized that it was so difficult to prove intent for the types of cases that they were bringing against hospital entities. So what did they do? And it's an interesting evolution of a statute, which was the Lincoln Law in 1863, wow, where Lincoln was distraught over corruption in the Department of Defense. It was a criminal statute then. And over the years it evolved and it became the Civil False Claims Act.
Okay.
And then the standard was a knowing or actual disregard for the truth. So what happened? The entities that submitted claims to Medicare were guilty of violations, even if it was erroneous as opposed to fraudulent. Okay. And they paid a $10,000 fine and treble damages. I liken that to what I see here with FCPA and the civil ramifications, because what they're doing is, yeah, they're lowering the standard. They don't have to prove intent, and in many instances, I don't think DOJ really wants to go to court
right,
with these cases. So this makes their life a lot easier. And let's be candid, Operation Restore Trust was a goldmine for the government. It generated millions and millions and millions of dollars, the same way the FCPA is doing today.
Did that operation ultimately change the conduct, do you think? I mean, was it effective?
It did. And what happened was that was really the birth of corporate compliance in healthcare entities. That's when it all started. And it only took the University of Pennsylvania to pay $30 million before everyone else got religion and decided we better get a proactive compliance program in place. It's the only way we can protect ourselves.
Interesting. Thanks for the history there. Appreciate it. But this is an interesting concept. Dick Casson wrote about this, blurred lines of accountability. And Joe, we're familiar with the critique that there were so few individual prosecutions during the financial and mortgage crisis. And the Justice Department's response was that in many of these cases, it was difficult to prove individual criminal liability in what were very complex financial cases. In other words, it was the organization that did it.
Yeah.
So Joe, can Yates really change that challenge?
I think it will. I think unequivocally it will, and I'll tell you why. I think what you're going to find is more and more investigations centering more on individual responsibility and misconduct as opposed to the entire enterprise. Okay. So when they're doing their investigations and they have intent to voluntarily disclose down the road, they're going to do it in such a way that they're going to be very cognizant of having to have a look at individuals, okay, who may have in fact crossed the line and committed various violations of the FCPA. I think once they do that, it makes the case for the government much easier, and it makes it more prosecutable. So I don't see any problem with Yates not being successful in getting to what their ultimate goal is, which is to identify individuals and get away from prosecuting the entire entity as opposed to the people who are really responsible.
Do you think Yates was like a new line in the sand on that, or sort of a restatement of what had been policy, but maybe now a renewed commitment to it?
I think it's a renewed commitment, and I think that's probably better put. I think you'll see the government is very intent on identifying the people involved. Right. And I think more and more the investigative techniques that you're going to see that are going to be utilized by the government will illustrate and support my contention. And I think case in point, when the FBI starts doing sting operations to nail individuals, that's prima facie evidence of what I'm saying to be true.
Sure, understood. Well, let's switch subjects for a second. Now we have the privacy shield in the European community. And we know from other FCPA cases that many multinationals have centers of leadership and teams in both the U.S. and Europe. So how can companies deal with cooperating with the Justice Department in cases where collecting data to transfer to U.S. investigators, or Joe, even into internal investigators, might now be restricted?
I think what we've seen, and I think it's an emergence from Siemens, greater international cooperation.
Right.
People, and let's face it, if you went back 10 years, you would see that very few countries really had something comparable to FCPA.
Right.
Now, Brazil has their own clean corruption act.
Sure.
Italy has one. Germany has one. And I think Switzerland was always one that was always cooperating from the inception. So the bottom line here is I think what's going to be worked out is an arrangement with all the international community to basically say, look, we have to get by this particular restriction and ensure that when there's an investigation that needs to be conducted, as part of our cooperative effort, we're going to ensure that we provide each other with the data that's necessary to bring it to fruition.
So not to get in the way of the internal investigators to support their work and also potentially to support what the government might be interested in.
That's exactly right. And I think you're going to see that very, very soon.
All right. Well, let's talk about individuals now who might be called into an internal investigation. Mm-hmm. Do you think that they're going to be less likely to cooperate if they know they have criminal liability? Joe, for example, I cooperated in my company's internal investigation because I hoped that my problems would have ended with just getting terminated, and I wouldn't have ended up at the Justice Department. So I was willing to take those odds. Now, do you think that individuals now who get counsel quickly will realize that no matter what, they're going to end up at the DOJ's doorstep? So why not tell the story in their own narrative by getting there first? And a defense attorney might see that as the best strategy to potentially mitigate their client's liability through the plea process. So if you think that scenario is likely, what does that mean for internal investigations?
Well, think about what you just said. If I'm an attorney for you,
right,
and you're a potential defendant, and I bring you in early to get you the best deal possible, that helps the government because then you're cooperating.
Right.
And you are in a position to give them the information they need. It's a win-win for both sides if you really think about it. I don't see that as a negative as far as the government getting the cooperation they need to bring these investigations to fruition. I see it as a positive.
No, I agree with that. But what about for internal investigators at the corporation? Do you think they're going to be less likely, even on an initial interview, to get cooperation from someone who knows they may be in trouble?
Yeah, well, look, if someone thinks they're in trouble internally, they're not going to be cooperative.
Right.
I mean, if I have done something wrong and the government comes and wants to question me, what's in it for me to cooperate? Right. Other than what we just described, getting in line and trying to be the first one
right
there to get the best deal. So, I mean, I think, yeah, it probably would restrict cooperation to some extent. Internally.
Right.
But those same internal people who are being scrutinized are probably going to lawyer up immediately,
right,
and be online and say, what's my number?
Right.
And let me get the best deal possible for myself, because that's exactly where they need to be.
Well, it'll be interesting to see how some of those cases play out, because we're dealing with a new issue here.
True.
Interesting.
It's true.
Well, Joe, thank you for your time today.
Thank you very much for having me. I enjoyed it.
Thank you.
Okay.